Hello and welcome back to another episode of Quotes This Week presented by LiveLaw. I am your host, Syed Amir Hussain, and I'll take you through the most significant courtroom developments from across the nation. From the Supreme Court to local courts, I've got you covered with crisp and clear summaries. But for a deeper understanding, I will always encourage you to check out the news articles available on our website, www.livelaw.in. In this episode, we are going to talk about the Electoral Bonds verdict, suo motu action relating to Sandeshkhali violence, pleas relating to the farmers' protest, and much more. So let's dive into the headlines. Beginning with a significant update from the Supreme Court. After a series of hearings spanning 3 days, a constitution bench led by CJI Chandrachud and including Justices Sanjeev Khanna, B.R. Gavai, J.B. Pardiwala and Manoj Misra has delivered a long-awaited verdict on the Electoral Bonds case. This week, the court declared the Electoral Bonds scheme unconstitutional, citing it as a violation of the right to information under Article 19(1)(a) of the Constitution. The bench noted concerns that anonymous electoral bonds allow financial contributors to wield undue influence over politics, potentially exchanging funds for favors. As a part of its directives, the court ordered the issuing bank to cease the issuance of electoral bonds. Additionally, the State Bank of India, SBI, has been instructed to furnish the Election Commission of India with information regarding electoral bonds purchased since April 2019, including details of political parties receiving contributions through these bonds. Launched in 2017, the Electoral Bond Scheme enabled individuals and companies to donate funds to political parties without donation limits. However, the lack of transparency regarding donor identities raised apprehensions about political and indebtedness and influence. Here's a quick update on the NewsClick news portal matter. This week, the Supreme Court permitted the company behind the portal to withdraw its appeal against the Delhi High Court's decision regarding an income tax demand. The court suggested that the company pursue its case with Income Tax Appellate Tribunal instead. Furthermore, the Supreme Court emphasized that if the company seeks urgent consideration for temporary relief, the tribunal should promptly address the matter. Previously, the news portal contested the rejection of its application for a stay on tax payments during the pendency of its appeal against the assessment order. The Delhi High Court dismissed its plea, prompting an appeal to the Supreme Court. However, this week, the company opted to withdraw its petition. Justices P.V. Nagaratna and Augustine George Massey granted permission for withdrawal, allowing the company to approach the Income Tax Appellate Tribunal. The court also directed the tribunal to expedite its decision if the company seeks quick consideration for interim relief. The Supreme Court has made a significant observation regarding abetment to suicide under the Indian Penal Code. In a case where a girl tragically ended her own life after her boyfriend suggested that she marry according to her parents' wishes, the court found that merely advising a partner to marry as per parental advice does not constitute abetment to suicide. The boyfriend's family subsequently initiated a search for a bride for him, leading to distress for the girl. The police filed an FIR against the boyfriend for abetment to suicide, but the High Court refused to dismiss the case. Upon appeal to the Supreme Court, Justices Vikram Nath and K.V. Vishwanathan reviewed the allegations and determined that the appellant could not be held guilty of abetment. The court emphasized that advising a partner to marry someone else amid a breakup without actively facilitating suicide does not amount to abetment. It highlighted that heartbreaks are a part of life and do not necessarily entail criminal culpability. The Supreme Court declined to consider a PIL petition brought by the Internet Freedom Foundation challenging the constitutionality of the Criminal Procedure Identification Act of 2022 and its associated rules. However, the court granted IFF the liberty to present its case before the relevant High Court. Justices Sanjeev Khanna and Dipankar Datta presided over the hearing of the writ petition jointly filed by IFF and the Criminal Justice and Police Accountability Project (CPAP). For more context, the Criminal Procedure Identification Act of 2022 replaced the long-standing Identification of Prisoners Act 1920, which primarily involved recording finger and footprint impressions and photographs of certain individuals under magisterial guidance. Internet Freedom Foundation's petition contested the expanded powers bestowed upon the law enforcement agencies by the CPI Act, allowing for the collection of various biometric data from individuals entering the criminal justice system. Alleging excessive delegation of authority without sufficient privacy safeguards and due process, the petitioners emphasized concerns about recent changes in rulemaking provisions and the intricate relationship between different legislative acts. Despite specific concerns raised during the hearing, the bench suggested that the High Court should be approached first, stating that the Supreme Court should not be the court of first instance. The Supreme Court this week granted leave to Arvind Kejriwal, leader of the Aam Aadmi Party and Chief Minister of Delhi, in a special leave petition seeking discharge from a criminal case related to his alleged remarks about Khuda believers during a 2014 political rally. Justice M.M. Sundaresh and S.V.N. Bhatti, presiding over the bench, also extended the stay imposed last year on further proceedings before the special court. Interestingly, Justice Sundaresh expressed regret that such matters had to reach the apex court. For context, Kejriwal faced controversy for allegedly stating during the 2014 rally that those who believe in Khuda won't be pardoned if they vote for the Bharatiya Janata Party. This led to an FIR against him under Section 125 of the Representation of Peoples Act 1951 for purportedly violating the Model Code of Conduct. In February last year, the Supreme Court issued notice in Kejriwal's petition granting him interim relief and temporarily halting the trial proceedings, which was later extended in May. This week, JNU scholar and activist Umar Khalid withdrew his bail petition from the Supreme Court. Khalid, who has been in custody since September 2020 under the Unlawful Activities Prevention Act, that is UAPA, for his alleged involvement in the communal violence in Delhi in February 2020, opted to seek bail afresh before the trial court due to a change in circumstances. His counsel, senior advocate Kapil Sibal, clarified that Khalid's challenge to the constitutionality of UAPA provisions would continue separately. The Supreme Court began hearing a batch of petitions challenging various aspects of the UAPA. Senior advocate Huzaifa Ahmadi argued that certain provisions of the Act violate constitutional rights and international obligations. However, the bench questioned the standing of the petitioners. Advocate Prashant Bhushan commenced oral submissions on behalf of individuals booked under the UAPA in Tripura, focusing on the Act's definition of unlawful activities and bail provisions. The state of Tripura argued that the matter should be addressed by the High Court since it primarily sought FIR quashing. Bhushan requested time to consult and the hearing was adjourned to the following day. This week, a public interest litigation was filed in the Supreme Court requesting a Central Bureau of Investigation or Special Investigation Team probe into allegations of sexual assault in Sandeshkhali, West Bengal. The petitioner alleges collusion between the West Bengal police and Trinamool Congress leader Shah Jahan Sheikh, the main accused. The petition highlights an alleged attack on Enforcement Directorate, that is ED, officials during a raid on Sheikh's house, leading to his disappearance. Subsequently, women, mostly from the scheduled caste and scheduled tribe communities, protested against Sheikh and other political figures. The petitioner expresses concern that a fair investigation is unlikely under state police and urges Supreme Court's intervention to ensure impartiality. This week, the petition was mentioned before the Chief Justice of India for urgent listing, and the matter will be reviewed. Notably, earlier this week, the Calcutta High Court initiated a suo motu case on the same issue. Here's more information about the suo motu action initiated by the Calcutta High Court this week. The High Court has overturned the imposition of Section 144 of the Criminal Procedure Code in Sandeshkhali, West Bengal. following unrest over allegations of sexual harassment and illegal land grabbing. Acting on its own initiative, the court addressed petitions from Sandeshkhali residents aggrieved by police actions. The petitioners claimed that individuals associated with the ruling political party were engaged in unlawful activities, including land grabbing and sexual exploitation of women. Demonstrations by women led to the imposition of Section 144, but it was argued that the police were supporting the perpetrators. The state's Advocate General contended that many arguments were not relevant to the writ petition. Justice Jai Sen Gupta, after hearing the arguments, expressed sympathy for the villagers' plight and emphasized the importance of addressing the main wrongdoers rather than restricting villagers' movement. Citing Supreme Court precedents, the court found the satisfaction test for imposing Section 144 not adequately met in this case. Therefore, it annulled the order and directed police to prioritize apprehending the offenders, enabling women to safely file complaints. In this week's legal update, the Gujarat High Court has dismissed pleas by Delhi Chief Minister Arvind Kejriwal and Rajya Sabha MP Sanjay Singh challenging a session court's decision to uphold summons issued against them in a defamation case filed by Gujarat University regarding Prime Minister Narendra Modi's education degree. The High Court bench, led by Justice Hasmukh D. Suthar, reserved its orders after hearing arguments from both sides on February 2nd. Kejriwal and Singh approached the High Court last September, 4 days after their revision application was dismissed by a sessions court in Ahmedabad. The appeal also raises concerns about the potential chilling effect on freedom of speech and expression. Last month, the Supreme Court stayed the criminal defamation proceedings against Kejriwal and Singh. Despite Singh's plea to transfer the case out of Gujarat, the Supreme Court deferred the decision to the Gujarat High Court, granting 4 weeks for interim relief considerations. Meanwhile, the defamation case before the trial court remains stayed. The Karnataka High Court has rejected the plea of Veena Vijayan, Director of Exologic Solutions and daughter of Kerala's Chief Minister Pinarayi Vijayan, to quash the Union of India's order directing the Serious Fraud Investigation Office, that is SFIO, to investigate the company. Justice M. Nagaprasanna's bench, which had reserved the order last week, instructed the SFIO not to take coercive action against the company until the verdict was announced. Additionally, the court mandated Exologic Solutions to provide the requested documents to the SFIO. The controversy surrounding Exologic Solutions arose when reports revealed that Cochin Mineral and Rutile Limited, that is CMRL, allegedly paid 1.72 crore to the company from 2017 onwards. An order from the Income Tax Interim Board of Settlement suggested that CMRL made these payments without receiving any services, leading to suspicions that the fraud were kickbacks disguised as payments for IT services. Farmers from Punjab, Haryana and Western Uttar Pradesh have resumed protests in Delhi, demanding financial support for farming, including a guaranteed minimum price for crops. Police in Haryana and Delhi have increased security, sealing borders to prevent entry into the capital. 2 PILs have been filed in the Punjab and Haryana High Court, one challenging border closures and the other criticizing protesters for blocking highways. The petitioners argue for the right to protest peacefully, citing recent government actions hindering demonstrations. The government, while open to negotiations on minimum support prices, emphasizes the need to avoid public inconvenience. The court called for a peaceful resolution recognizing protesters' rights while urging the state to protect citizens from disruption. The case is scheduled for 15th February with notices issued to relevant authorities. That wraps up this week's legal news roundup. But before I go, I have a little request from the entire LiveLaw team. We are an independent, fact-driven media organization that is committed to fearless and ethical journalism. To keep delivering your daily and weekly legal updates, especially in this dynamic audio-visual format, we need your support. So don't forget to do the Fantastic 6. Give our video a thumbs up. Share it with your family, friends, classmates and colleagues. Make sure you're subscribed to our YouTube channel. Drop your thoughts and feedback in the comments below. Tap that bell icon to get your notifications. And lastly, swing by our website at www.livelawmedia.in for our in-depth reports. I am your host Syed Amir Hussain and I will see you again next time.